rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. All right, we are here for argument in our case number TX24-0002, A&P Ranch versus Cochise County et al. So, initial reminder to everyone in the courtroom, please silence your phone so that we can avoid any embarrassment or disruption. As you know, we record and live stream these proceedings, so please introduce yourselves when you begin. You each, or I shall say each side, has 20 minutes maximum for your argument. You're not required to use all of your time, but you are welcome to do so, and it is up to you to track that time, including if you intend to share argument. Please keep in mind we have read the briefing, we are familiar with the record, we have conferenced and discussed this case just a short while ago, and with that, you can proceed.
Good morning. May it please the court. I'm Paul Correa. I'm privileged to be the Chief Civil County Attorney in Cochise County. And I'm representing the county's assessor here today. And I also want to mention and thank Mojave County for filing its amicus brief. So this is a case that is important to Cochise County. And important to all rural counties that have orchards and vineyards as part of their tax base. The tax court got it wrong. It blew a hole through the county's tax base and budget by erasing a type of property, an improvement on agricultural land that has been taxed as an improvement on agricultural land for over 40 years. And farmers have not said boo about it until the Schedule C from the department's ag manual.
Counsel, if I could just ask you, yes. Does the county's reliance on this tax base override the interpretation of the statutes?
This is a policy concern. I just want to point up at the head of it why this case really matters to the county and to the state. The tax court made several errors in the way that it read the tax code as it applies to agricultural land. And it relied on a case called Westward Look, which doesn't stand for the things that it was argued or stated by the court that it could. And these are errors that will lead to the erosion of tax bases across counties and additional litigation. And we are asking this court to fix that. It is really quite a shocking departure from the way that the law has been settled and understood. You have read the court's ruling, its judgment. So I'm going to use that sort of as a template just to go through the errors and speak as we go along. I'm going to leave some time for Kim Seigan from Department of Revenue to answer any questions that you have. So.
Counsel, let me ask you a question about the last paragraph of Judge Agnews' order.
Yes.
So she talks about uniformity among classes. So can you talk about how your take is that's wrong, that her interpretation is wrong? Talk about this last paragraph.
Yes. So I think it's uniformity within classes of similar property. And Department of Revenue has done a good job of pointing up that, in fact, it's not as brittle or blocky as it's suggested in the judgment. There is nuance, so that within classifications of, say, Class 2 property, there could be something like dairies that are going to have higher value improvements on the land and are going to have a valuation that is somewhat higher when you look at the total valuation of the property, including the underlying ag land plus the improvements. That's okay, that's normal. That doesn't offend the uniformity. Now, as a matter of fact, in this case, uniformity does exist and was respected and applied by the county assessor. All ag land is valued for 2023 at $1,800 an acre. regardless of what crops may be on it or what improvements may be on it. So that is uniformity being respected, and that you start with a base of $1,800 per acre for all irrigated agricultural land. And that is consistent with the direction and intent of 42-13-101. So if I may, I'll just segue into that.
But then if the assessment differs based on what improvement, I'll use the word improvement. I don't know if I'm using that correctly or not, but based upon what type of crop is grown on the land, how is that then uniform?
Well, that is not required by the uniformity clause. The uniformity clause applies to the valuation of agricultural land within the class of ag land that is valued as ag land. I don't think it's reasonable to expect that if you've got a much more valuable improvement on your ag land than your neighbor farmer does, that your tax bills would be the same.
Can you address that response within Judge Williams' follow-up question, which is as within crops?
Right.
So setting aside the dairy farm or other type of, but as within, so for example, within types of permanent crops, can there be discrepancies in terms of this uniformity principle?
Sure, yes. Vines and orchards may have different market values as improvements, and so there would be a difference in
what's the authority for that, to say that our Constitution doesn't preclude that?
The authority to say that there's not a constitutional preclusion for a difference in the value of improvements.
We have a
The
constitutional
Constitution does not
Let me
address
finish
that.
my question.
Yes.
We have a constitutional provision that says you have to be uniform. You're saying, no, you don't. You can value an orchard of oranges different than you can value a vineyard of grapes. What is the authority for that?
So within the code, there is a class.
What's the authority to say that constitutional uniformity does not require uniformity among the crops, regardless of the value?
Well, you are still treating like properties the same.
Okay. Is there a case or something that, when I'm saying authority,
Yes.
it's like, help us understand that
Sure.
that's not what, what seems to be kind of a plain reading, and I hate to say plain because nothing's ever plain, but when you have a statute or constitutional provision that says this, don't point me to a code provision that says something different. Is there a case, a Supreme Court case or something that has said, this doesn't mean this, what it seems to mean?
Yes, there is, and this was cited by Department of Revenue in its opening brief. So if you bear with me, I'm going to burn up some time and look for that.
I'll even let you just say it's cited in the brief, and Judge, you should have read it and go look at it.
It is cited, and this is where I began by saying that it's not as blocky or wooden, and I believe that is a Supreme Court case that talks about the uniformity clause. So this is cited as America West Airlines versus Department of Revenue 179 Arizona 528. There's another site that runs on. So I'll read from Department of Revenue's brief. It says, the Arizona Supreme Court expanded on the clause's import, stating that it requires that similar property used in the same industry for the same purpose cannot be classified and taxed differently for ad valorem taxation simply because of the size, wealth, or location of its owner. And I believe that does answer the question and stands for the proposition that there is a logical and allowable difference in the total valuation of a property within industries if they have different uses, different purposes within that same industry.
So just so I understand it then, and that makes me feel better that I hadn't just ignored an obvious case. I thought you were going to cite me a case that says crops are different. But what you're saying is the America West, long may she be remembered. I used to love when we had our own airline here. But America West says that purpose or a different purpose can lead to a different tax valuation, and that doesn't violate uniformity.
Yeah, that's the Arizona Supreme Court.
And your argument would be then purpose, a crop of oranges is a different purpose than a acre of vines.
So, and I'll read in the quote, similar property used in the same industry for the same purpose cannot be classified differently for ad valorem taxation simply because of the size, wealth, or location of its owner. So the uniformity clause here is respecting that the base land in the class 2 is valued the same and allowing for a difference in the specific subcategory within that class 2 industry.
Thank you.
Okay, so let me move on to like structural arguments. There is a system in the Arizona Department of Revenue's, I'm sorry, in the tax code. There is a section, a chapter 12 that talks about classification. Chapter 13 talks about valuation. So two different chapters, two different action verbs. You've got classify and then value, and in that order. In this case at hand, in ARS 12-151, I'm sorry, ARS 42-12151, there are some clues in the language that are significant here.
Let me just
Yes.
understand something there. You're
Yes.
saying all of 12 is about classification. And then you took me to the definition statute, not the classification eligibility statute. So are you
okay.
saying the definition statute sort of serves a secondary function as a class, like it creates classifications?
I'm talking about ARS 12-151.
42-121
Yeah, 42 yes.
is the definition statute, isn't it?
And I will read from it.
It's titled
So,
Definition of Agricultural
Definition of
Real
agricultural
Property.
real property, yes. And this tells us what components exist on a piece of real property that would allow it to be classified as ag property. So agricultural property means real property that is one or more of the following. One is cropland, subsection 1, and I've made a lot about the distinction that follows subsection 2 is an aggregate 10 or more gross acres of permanent crops. So in 1, we're talking about land, just dirt, and in 2, we're talking about dirt plus something. And that statute continues in that same vein, talking about land and improvements. So here we can see that there are two distinctions that exist in the legislature's mind. There's a difference between land and improvements, and there's a difference between cropland, which exists whether it has crops on it or not. It's cropland of at least 20 acres. And that's distinct from agricultural land that has 10 or more acres of permanent crops. Permanent crops is not defined, but Department of Revenue is instructed to create manuals, including the Ag Manual, which for at least 40 years has provided a definition of permanent crops, which includes pecan trees and pistachio trees and vineyard vines, which are at issue in this case. So that is a distinction and language that matters. The courts are instructed that when they're construing statutes or a statutory scheme, they should give meaning to each word and each
So let me just probe you a little
Yes.
bit. On the aggregate 10 or more gross acres of permanent crops, why is that not a statement of an aggregate 10 or more, so gross acres is a measurement of land
Yes.
containing permanent crops.
Mm-hmm.
So number 1 talks about cropland that's 20 acres.
Yes.
Number 2 is land containing crops that is 10 acres.
Yes.
I'm not sure I see the distinction that you were trying to draw there, that number 2 does not include land. It's just, or the land and the crops are somehow separated in a way that
Well,
I'm just not sure I see that in the
Cropland
text.
is cropland, whether there's corn on it at any given time or not, right? It is planted, it is grown, it's harvested, and it's tilled under. And that bit of cropland, then, if it's being used in rotation, will be left fallow. It is still cropland. It is dirt that you can grow stuff in, and it has usually, water rights, so it's irrigable. That makes it cropland.
And land containing the sort of the mechanism for the permanent crops, I'm not sure that I see a distinction there. So land containing the trees or the vines or, pardon my ignorance, but whatever it is that you would refer to alfalfa by, but that's a permanent crop that repopulates itself without
Yes.
reseeding.
So
The land containing those would continue to be land containing those regardless of whether or not they are producing.
Yes, and so would, a dairy that is land with improvements, it is still land plus improvements. The difference between cropland and a pecan orchard is that those trees are going to be there. If you sell it, you're going to sell it with the trees. If you sell cropland, you're selling raw dirt with the ability to irrigate it, and a history of it being used in that way. So there doesn't have to be anything on cropland for it to be cropland. And that's different than everything else that follows in this definitional section of this chapter. So permanent crops, you refer to them as sort of a mechanism, and I'll just point out, detail in the record. In fact, these are intense capital investments, and the record contained a statement from one of the farmers, AMP Ranch, which actually, if you look at the whole docket, owns quite a lot of land, and it's really ag industry. $20,000 an acre is required to bring young pistachio trees into maturity to produce. And after that, they may live to be 100 years. So they are really improvements on the land, capital investments similar to a barn or silo.
Is improvements defined anywhere in statute relevant here?
There is there is a Department of Revenue manual.
Right, but in statute, is it
No.
defined anywhere?
So I want to turn to, again, continue with the structural argument and the interpretation of the statutes. 13101, I'm sorry, Judge, did you have a question? No. 13101 begins with the statement that land that is used for agricultural purposes shall be valued using only the income approach to value without any allowance for urban or market influences. Now that clause stands alone. The judge seemed to think that it should be read in paramateria with the following clause, which says the income of agricultural property shall be determined using the capitalized average annual net cash rental of the property. So it seems, and this is plaintiff's argument, that agricultural property was then imported into the first phrase when it doesn't need to be, and it operates correctly without performing that operation. You're talking about the valuation of land, and we have cited in the briefs the legislative history. 13101 in its current iteration, was enacted, beginning in 1980 to protect farmland and not to protect the things that are built on farmland. This was to protect farmers from having their land valued at the market rate. If it's on the border of a town, that's going to be driven up and will lead to speculation and loss of agriculture. So that was intended to protect dirt, and that is exactly what this says. You don't need to add anything to it. Land that is used for agricultural purposes shall be valued. It doesn't say land and improvements, and we know from looking at the prior chapter, the legislature knows how to do that if they intend to do that. I'm down to 2 minutes, so I just want to emphasize that the court's reasoning here creates a very dangerous problem, because when the court looked at this statute and said, it doesn't say anything about improvements, and it doesn't say anything about trees or vines, therefore, she's going to conclude that those are not to be valued separately, but should be included in the land. It does violence to the definition part of the chapter that does draw a distinction between cropland and permanent crops. So you don't need then to have that distinction. She erases subsection 2. It also creates a situation where anything that isn't identified in statute as an improvement that must be valued separately is vulnerable to not being valued at all. And she cites Westward Look, which dealt with a different statute and retroactive taxation. It doesn't create a rule that if an assessment doesn't include valuable improvements, that's okay because constitutionally it was taxed a little. That would do serious damage to the county's budget, and it doesn't accord with the intent and purpose of 13101 or the canons of construction that say you can't erase one section by interpreting another in a new way, and this is a radical departure. And you should just apply the plain language as it exists without adding anything to it. The judge did both of those things incorrectly. So she found that agricultural land...
You understand that the argument that it impacts the county's budget is
Yes.
not what's going to drive this court, a court of law, in determining how to interpret the statute. It's going to be the language of the statute. You
Right.
understand that, correct?
Yes, I want to point out the danger, though, in the ruling if it stands. Agricultural land is to be valued pursuant to ARS 4213-101. The court found the plain language of the statute does not countenance valuation of permanent crops separate from the land. Well, it doesn't countenance valuation of anything separate from the land in that statute. So, by this argument, all improvements on agricultural land should be exempt. That is the ruling as it stands, and that does need to be repaired.
Thank you, counsel. We did also want to hear from the Department of Revenue, so I'm going to add 5 minutes to both sides and invite counsel from the Department of Revenue. Go ahead and make your, whatever you were planning to say now. Yeah, sorry, that wasn't to suggest that you're not permitted to save any time for rebuttal. I'm just...
But you had no time, so we're gifting you 5.
Yeah, no, I understand. No, I just wanted to clarify when you wanted to hear from me. So even though this is a locally assessed matter and the Department of Revenue here did not do the valuation, the department intervened here in order to help the county defend the methodology. So I just wanted to be here to clarify any questions that you may have concerning the methodology, not necessarily any specifics about the valuation. So.
Our largest concern is about the interpretation of the statutory language. To Judge Williams' point, we understand that there may be impacts of our rulings, but we can't allow the potential impacts to drive what the law says. So if you would like to address the interpretation of the statutes.
Sure. So the legislature chose to use very different language in ARS 42-12-151, subpart 1, which says crop land, and then subpart 2 says permanent crops. Significantly, the legislature did not use the term permanent crop land. So to give the term permanent crops some meaning, it has to mean something more than simply the underlying land. And I think in that case, the land is implicit because we all know that you can't grow a pistachio tree in a pot. And we cited numerous authorities that consider things like trees and vines to be permanent improvements. And I think the legislature understood that when it, what permanent improvements. And I think the legislature understood it when it used those, when it used permanent crops, that it meant improvements to property. The other thing I do want to clarify too is that the plaintiff's argument is that the statutory method in ARS 42-13-101 should be used to value the trees and vines in total. And according to the plaintiff, if trees and vines have value in addition to the land, then that statutory method should capture the value. And there's a problem with that for a couple of reasons. First, as I said earlier, the legislature chose to create a separate taxable class of agricultural property called permanent crops. And so that decision by the legislature must be given some kind of effect. But the second problem with that argument is that...
Sorry, just really quick on that first one. Couldn't we read that 1 and 2 as being a distinction between, I mean, it's also a distinction between size. So the legislature was saying the big cropland or the slightly less big land that contains permanent crops.
But again, it didn't use permanent crop land. It said permanent crops.
But it says acres of, and an acre
is a unit of measure, correct, right.
But it is a unit of measurement of land, correct?
Right, and I think the land is implicit.
Right.
But again, it's using permanent crops. It didn't say permanent crop land.
Okay.
But I want to go back to the second problem with the plaintiff's argument concerning why you can't compare leases of vineyards and orchards is because they're non-existent. So land, orchards and vineyards are either owned outright or else just the underlying land is leased. And the assessor testified that he couldn't find any leases of orchards.
How is this not another policy argument, though, in the sense that the legislature has prescribed a way of doing things, the fact that in sort of reality it plays out more difficult or complex, or how does that change the interpretation of that law?
It doesn't. My point is that even if there were leases of orchards and vineyards, that is only used to determine the land component. It's not used to determine the permanent crops component. That still needs to be done using standard methods and techniques. Because the agricultural land valuation method only is meant to determine the land. And you can use comparable land. So if there were leases of orchards and vineyards, then you could look at those, but there aren't any. And you have to keep in mind, too, what is the purpose of the statutory valuation for land? Is to protect land, right, from encroaching development, and it's to protect it from using market influences. But that protection doesn't necessarily extend to everything on the land. It doesn't extend to improvements as well. And I'm just going to save my time because I only have 22 seconds for rebuttal.
I have a question. I know we're out of time, but I have a question that I'm hoping you can touch on the uniformity clause under the Arizona Constitution. Agricultural, under land that's real property and improvements that are used for agricultural purposes, this classification of land has to all be taxed uniformly, correct?
So what the uniformity clause says is that property can be distinguished for taxation purposes based upon its use, utility, productivity, and nature. And our position is that cropland is different than land that has trees, because trees are just different. They're valuable, and they're more like an improvement than simply a tomato plant. The agricultural statutes are concerned with valuing land and improvements. So a pistachio tree is an improvement. A tomato plant is not.
Okay.
And
Thank you.
so.
Good morning. May it please the court, my name is Paul Mooney. I'm here with Paul Moore. We represent 16 owners of various agricultural properties in Cochise County. All of them confirmed to me today they were going to be live streaming this because they have busy lives growing crops, and they need to be at their business as much as possible, but I'm sure they're participating today online. I'm going to give a different argument than I thought I was going to give because of some of your questions. I want to clarify a couple really simple principles. First is, since 1967, in Arizona, we classify all property for tax purposes. Classification has one and only one significant implication. It relates to the assessment percentage that gets multiplied times the value. So, properties in classes 1, 2, 3, 4, etc. are assessed at different percentages of their value. That's not in dispute here. That all grew out of a case that came out of Tucson involving the Southern Pacific Railroad in 1963, where the railroad came in and said, we're getting screwed. Compared to all the other properties, we're supposed to all be valued the same, and the Supreme Court said, yep, you're right. The Supreme Court issued a lovely statement that said, refunds of taxes paid is a matter of legislative grace, and our grace does not extend unto our destruction. So we're not going to give you the refunds you want. But we're going to ask the legislature to study the problem and come up with a solution. And in 1967, the legislature promulgated a system of what was then 4 classes of property. And they assessed those classes at different percentages. At one point, we were up to 13 classes in Arizona. We've scaled that back now to about 9 or 10. The point is, each of those classes are classes of things that are similar. And so they're assessed at the common percentage. That is one measure of uniformity that is required in Arizona, to get to the question that was asked about uniformity. The second aspect of uniformity that's critical is that values must be uniform. The America West case that was alluded to earlier, if you read it, is a case that involved small commuter airlines that had airplanes that only carried so many passengers. Their planes were valued at half what they cost. America West had the same kinds of airplanes that they were using on in-state routes, and their planes were valued at 100% of their cost. So America West came in and said, that's not fair. The statute's unfair, it's non-uniform. And Chief Justice Feldman wrote the opinion in the America West case, and he said the uniformity clause is elastic, but it's not that elastic. You can't do that. And so basically America West won their case that their airplanes that were the same as the airplanes of other commuter airlines had to be valued the same way, and that the statute that provided for something different was unconstitutional. Okay? That's what America West stands for. There's been, since America West, another big case that the Supreme Court decided called Aileen Char, which is another valuation discrimination case. We've cited, I believe, the Aileen Char in our brief case, and I argued that at the Supreme Court, and Justice McGregor wrote that opinion and said you can't discriminate in the way you value apartment buildings. They all have to be treated the same. So let's apply those principles to this case. We start with a statute that's been referred to a number of times here today, but let's look at what it actually says. 4212-151 is a statute that defines a term. The term that it is defining is agricultural real property. And it then says agricultural real property means, and then it lists examples, one of which is cropland, one of which is permanent crops. And it gives those as examples, and others that follow, of things that qualify as agricultural real property. Now, that's important, but that's as far as 151 goes. There's no dispute about classification in this case. Every single one of the plaintiffs in this case has agricultural real property. That was stipulated. It's an undisputed fact. We start with that undisputed fact, and then we move over to the valuation statute that the legislature adopted to value agricultural property, 4213-101. I honestly do not understand how anybody can argue with a straight face that subsections A and B of that statute are not in pari materia with each other. That's ludicrous. Of course they're in pari materia. They are defining the same thing. One of the cases that we cited in our brief says this interesting statement. Generally, the term real property refers to land. Novel concept. So we just define what is classified as
let me ask you a question.
Sure,
here
go
on
ahead.
this, because the statute you're referring to only says land. In subsection A, it says land.
It does.
Okay.
So what?
Let's go back to 4212-002 that defines what Class 2 property is.
Okay.
Class 2 property under subsection 1A is real property and improvements to property that are used for agricultural purposes.
Correct.
So on its face, the statute you referenced talks about land.
But it also refers to agricultural property in subsection B when it articulates the formula that subsection A says is to be applied.
Right, but my point is, what I'm hoping, maybe it's basic and I'm just oblivious here, but 4212-002 talks about real property and improvements. But
Correct.
nowhere else in the statute do I see the legislature expressly stating what are improvements.
And they don't, and the statute doesn't define it, because the issue here is whether trees and vines growing on land that is irrigated are agricultural property. If they are, then they got to be valued under 4213-101.
And considered just as land. You're saying
Yes,
they're just land.
because the trees that are growing on the land are part of the land. We cited abundant case law that says that. We cited references to the Arizona Land Manual, the Arizona Ag Manual. All of these things say the same thing. They're referring to land as inclusive of the things that naturally grow on land. Rocks, trees, whatever it is, are part of the land.
But aren't there other cases that the Department of Revenue cited in their brief where other jurisdictions say
Sure.
orchards and vines are not part of the land?
If
They're
you're in New
improvements.
York, you're right. If you're in New York, under the New York case that they cite, the Northeast Fruit Council case, their legislation defined trees differently. Fine, they want to make that argument, go to the legislature. We don't go to the legislature. This court is not the legislature. This court is interpreting the statute. That's what the tax court judge did in this case. And the tax court stated, here, the plain language of the statute does not provide for different treatment of agricultural land based on different crops, nor does it indicate that agricultural land must be valued separately from permanent crops. There's nothing in any of these statutes that states or even implies that land doesn't include the crops and the plants that are growing on it. We don't assess crops for property tax purposes. We don't assess crops because crops are the product that's produced by the agricultural process. If they make a profit, they pay income taxes on the profits they derive from selling the fruits and vegetables and whatever else is grown on the land. We're talking about property tax, and nowhere in our property tax laws is improvement defined to include a living plant. Ironically, in this case, when it started, we were aware of the ag manual, which for years they just throw a little de minimis value on top of each property, and nobody complained because there wasn't enough money involved for anybody to legitimately challenge that. In this case, they came along and not only did they raise the value of the irrigated land from $1,200 an acre to $1,800 an acre, which they did correctly, no dispute about that either, but then they added $12,000 an acre instead of $600 an acre for orchards, and they added $8,000 an acre for vineyards instead of $100 an acre. So if you happen to be growing tomatoes in Cochise County that grow on vines, your land is valued, irrespective of the crop you're producing, at $1,800 an acre. But if you're growing vines that produce grapes on that same acre of land in Cochise County, your value is $9,800 an acre. That's not uniform. To answer your question earlier about uniformity, that's not even close to uniform. It doesn't even come into the neighborhood of uniform. Now, again, the same thing is true for the orchards. They went from a value of $1,200 an acre to $1,800 an acre on their underlying irrigated land, and then the trees, they added $12,000 an acre to those. So now they're at $13,800 an acre. Grow peanuts, grow peanuts on the ground and grow nuts on a tree, and you get treated vastly differently.
So let me ask you a question. Let's talk about Class 3 property for a
Okay.
second. Residential, correct?
Yes.
Okay.
Used to be Class 5, but
okay.
It's all right.
We'll say Class 3 is residential. Under a uniformity approach, a home in one part of a county and a home on another part of a county, they can be assessed at different rates, correct?
Well, tax rates are different. The tax rates themselves will be different. The valuation principles are that they are to be valued at market value, standard appraisal methods and techniques. They use a technique known as multiple linear regression analysis because they do what's called mass appraisal of homes, and they compare the square footages, the types of roofs, the number of plumbing fixtures, and a variety of other things.
I guess my point is it comparable for me to consider, in my mind? I'm thinking about a Class 3 classification properties being assessed different tax rates, even though they have the similar structures on each land, but in different parts of the county, to agricultural land having different types of homes, crops on them. Am I way off base?
No, you're not way off base, but you're confusing a couple simple principles. Article 9, Section 1 of the Constitution, the Uniformity Clause, says that the tax shall be uniform upon the same property within the territorial limits of the authority levying the tax. That's the rest of Article 9, Section 1. So tax rates vary all over the county because school district rates are different, and some people are in flood control districts and some people are in other special districts. And so the districts can vary and the rates will vary somewhat. It can actually vary quite a bit around the state. Those rates only have to be uniform within the taxing district that they're imposed on. So a home in that district may be assessed at a different rate than a home in another district. That doesn't violate uniformity because it's uniform within the territorial limits of the authority levying the tax. But
Which
the
is
values.
Which is the district, not the county? Is that what you're telling me?
I'm telling you that the way the Article 9, Section 1 reads says within the territorial limits of the authority levying the tax.
Okay.
And those are different districts, usually school districts or other special districts. And each of them has a rate. Cities have different tax rates, for example. Mesa doesn't levy a property tax rate. Scottsdale does. So if you have a house in Scottsdale, you're going to pay more than a house in Mesa just on that basis. But the value of the home, whether it's in Scottsdale, Mesa, Glendale, wherever, is determined using uniform methods. So those methods take into consideration things like square footage, location generally, because land is part of it, and all of that is factored into the mass appraisal system that's used. So that system produces uniform values that are uniform for purposes of the uniformity clause, both in terms of the valuation that's applied and the tax rates that are being applied. So that isn't at issue in this case. Right. The issue here is, can you treat some crops differently than other crops? If I'm a peanut farmer like President Carter was.
Just to put a fine point on that,
sure.
Can you treat some crops differently for purposes of valuation? So that's the carryover point here.
The legislature could, if they wrote a law that did that. But once you write a law that says all agricultural property, and that's the phrase used in 13101B, is to be valued based on its average annual net cash rental. So let's assume for the sake of argument that these guys are right, that orchards are worth more than bare cropland. Let's assume that for just a second. We have no proof of it in the record, and they weren't able to find any. But if that's true, the method the legislature selected to value agricultural property would capture it. You would go out and survey and find out, are orchards renting for more money than cropland that's just bare naked ground? And if that is true, then the value would go up, presumably, because the rental amount would be higher, and you're looking at an average annual net cash rental.
So
now,
what do we do with the Department of Revenue's point that there are no rentals in fact?
That contradicts the record, because there were leases that the assessor looked at and decided he didn't want to use. So that statement about what's in the record is simply false. They didn't do the legwork to go out and find what rental values were. They could have looked in California. They could have looked in New Mexico. They could have looked anywhere in the country, the same states that they're now pulling case law from, to argue that this should be treated differently in Arizona. They could have done that, but they never did their homework. And the fact of the matter is, the method that the legislature prescribed would capture additional value for orchards or vineyards if it in fact exists.
Would that violate uniformity, though?
No, it would not, because the method that's used to set the value is exactly the same. You're determining the method, the full cash value is determined. Let's step back for just 1 second. Full cash value, the first sentence of the statute, is defined as the value determined as prescribed by statute, period. Then it goes on and says, if no statutory method is prescribed, then you look at standard appraisal methods and techniques. As long as either of those is done uniformly, the uniformity clause is satisfied. The problem here is that they didn't do what the statute required, because they don't like the fact that under 12151, permanent crops are agricultural real property. Well, if they're agricultural real property, then they're subject to valuation under 13101 as agricultural property. And that means the average annual net cash rental. So if their supposition is correct, and that's all it is supposition and speculation, that orchards and vineyards would rent for more money, then all they have to do is go out and find evidence to support that. They didn't do that here. They simply added on top of the method that the legislature prescribed an arbitrary number that was so big that they couldn't ignore it anymore. You know, ironically, I was telling my partner this morning. I was thinking about this last night. You look at tax year 22 and tax year 23 in Cochise County. The assessor raised the land value from 1,200 an acre to 1,800 an acre. No dispute about that. In 22, using a table that has since been disposed of by the Department of Revenue, for orchards, they were adding $600 an acre. So in tax year 22, a nut orchard was being valued at $1,800 an acre. The tax court's ruling in this case values the nut orchards at $1,800 an acre, but doesn't allow them to add $12,000 more per acre for the nut trees, because that's not in the method prescribed by the legislature. That would be improper, because it doesn't follow the method the legislature set. And the Supreme Court in the Trico case, which we also cited in the brief, very clearly said, Article 9, Section 11 of the Constitution vests discretion on the manner, mode, and method of assessing property exclusively in the legislature. We may not like it, but the legislature is the one that has the power to do this. If you want to change the law, if you're absolutely convinced that the legislature intended all along, and there's no evidence of that, to value orchards and vineyards at a higher value, or to treat those as improvements to real property, go to the legislature and change the law. They're the only ones that can do it. The tax court judge ruled based on the law. The court's conclusion is consistent with the doctrine that tax statutes to be interpreted liberally in favor of the taxpayer and strictly against the government. There's no evidence that agricultural land must be valued separately from permanent crops, and there isn't. The tax court was correct. There's absolutely no question. The tax court construed the statute according to its plain language correctly. And the only defense they really have is say, well, we've been doing this for 40 years. By the way, I'm just making an aside. There's no evidence in the record that they've been doing it for 40 years. All they could establish was that they've been doing it as long as anybody can remember. That's literally what they did. We took 30B6 depositions of 2 Department of Revenue employees in this case to say, where did you get this language? Where did you find this sentence that you're relying on, that permanent crops have to be valued as improvements? Their first response was, well, they're living improvements. You know, I did an interesting Google search on the term living improvements. No such term exists. Never been used by anybody. So they walk away from that and they said, well, they're insurable. The trees are insurable. If a tree gets damaged, they get insurance. So they're insurable just like a building. Only problem was, when they asked for the insurance policies and we provided them, they found out something interesting. The insurance doesn't cover the trees. It doesn't protect the trees. The insurance protects the crop. The insurance is crop insurance. There is no insurance on the trees. If a tree dies from disease or doesn't get enough water or fertilizer or gets blown over in a windstorm, tree's gone. There's no insurance like on a building. And so that was their argument about improvements. And you're right. In the intro section to 12, you're right. It does talk about improvements.
And then it's never addressed.
Yeah,
it's just left out there.
Here's why. If you look, most agricultural operations have fences around them. Fences are improvements. They have buildings, barns, oftentimes, to store things, fertilizer and other things. Those are improvements. No question. There's no dispute in this case about valuing those improvements. Those are improvements under the common definition of the word. By the way, there's an entire section in the land manual that talks about what land is, and it defines it to include the plants. But interestingly, in the next section of the land manual, we cited this in the brief, they define improvements. Nowhere do they list plants.
Is your point in saying the buildings, the barns, the fences, those can all be considered?
Yes, those have to be considered, because those aren't going to be, I mean, one farm might have a piece of bare dirt, and you're going to rent that. Another farm might have a piece of bare dirt and 3 buildings. Well, you probably would pay more rent for that, but the point is that the way the appraisal method works, you would value those improvements separately. They'd be valued using standard appraisal methods and techniques, because the statute doesn't apply to the land that's producing the crop. Simply put, there is absolutely nothing in the history of these statutes or any case law in Arizona, anywhere, that says you value anything other than agricultural land when that's what you're That's what your focus is. That 13101 statute applies to the valuation of agricultural land and agricultural property. And I might add, as I quoted a minute ago, generally, the term real property refers to land. What were we defining in 12151? Agricultural real property. So, if this is all agricultural real property, and they've stipulated to that, the record's undisputed, then 13101, even if it only applies to, quote, land, that land includes the crops. That includes the plants. It includes whatever's growing on the land. And there's no reason to interpret it differently. There's certainly nothing in the statutes that would give you a basis to decide the case on that basis. I want to make one other quick point. It didn't come up, but they've talked a lot about it in their brief. You would think, based on the way it's argued, that we argued somehow that we were exempt from tax. You will search the record in vain for any evidence that we argued that. We've never argued that we're eligible for an exemption. We've never argued that we were exempt. We responded to their arguments that this would be an unlawful exemption. It's not. The land includes the plants that are on it. Nothing got exempted. It was all valued and taxed the way the legislature prescribed. There's no Article 9, Section 2 issue in this case. You can't cobble one together by saying that our argument means somehow we'd be getting an illicit exemption from tax. We aren't asking for an exemption. We never asked for an exemption, and we don't believe we've received an exemption. We believe our property valued at $1,800 an acre, the irrigated land that we're using to grow nut trees and vineyards, was fully valued and properly taxed.
So in response to their policy argument that this is going to blow a hole in the budgets of rural counties, would your response be, well, they blew it themselves for the prior years, but going forward, if they want to go out and do the work and find out a rental value, they don't even have to go back to the legislature to fix it.
Ironically, if you go back and read their briefs, they actually say that there isn't going to be any fiscal impact from this change because the limited values aren't going up. It's as though they're saying it's okay for us to discriminate against you on full cash value because you're going to pay the same taxes anyway under the LPV. The problem with the LPV argument, as this court is well aware from Casimir and some of the other cases, Machu and 5133 and other cases that we've been involved in front of this court, the problem is there's this little thing called Rule B that comes along and you get to be revalued at a percentage of your full cash value. So the legislature has made it clear that what you can appeal is your full cash value. That's what we did. And so I don't think there's any fiscal impact, to answer your question, Judge Morse.
Well, there will be for the prior years. Or you guys wouldn't be here if there weren't.
Well, no, actually, my clients seriously debated bringing this lawsuit in the first place because of the very LPV argument that they made. But now they're arguing out of one side of their mouth that there's no fiscal impact here. And then out of the other side of their mouth, they're telling you this is cataclysm. It's going to be an apocalypse.
Thank you, counsel.
I don't have time to say it, but I've heard that argument before. Let's just say it that way.
I appreciate that conclusion. Mindful that the Department of Revenue did attempt to save 30 seconds and that we took that with a question, we will give you 30 seconds for rebuttal if either of you would like to give a 30-second rebuttal.
Okay, that'd be great. Let me just think real quick about how I want to use my 30 seconds. I think the biggest argument that I want to make is that the trees and the vines do not become part of the land where you can use the land formula to value the whole things in total. The legislature, again, specifically distinguished between permanent crops and crop land. And under plaintiff's argument, well, they become part of the land. Well, that's true with any improvement because as a general rule, improvements become part of the land to which they are attached. So under that argument, then everything would have to be valued under the land method. And in that case, then you're giving a market influence to everything, all improvements. There's really no distinction between a tree and, say, a building. They both are considered to be improvements, and we cited a lot of cases to support that.
Thank you,
They are-
counsel.
Okay.
We appreciate your rebuttal. We appreciate all your assistance today. We'll take this matter under advisement and issue our decision in due course. Court is adjourned.